Check 1 2.
Hey, Doug. Doug. Hey, Doug, you want to come up here? Okay, everyone, welcome to today's Board of Adjustment meeting, September 11th. We're going to start with the Pledge of Allegiance. Jason, if you could help lead us.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you. Jamie, if you could please take a roll call.
Here. Mr. Mead?
Here.
Ms. Rathburn? Here. Mr. Stressa?
Here.
Mr. Hagopian?
Here.
Mr. Wolf? And Chair Elfman.
Here.
You have a quorum.
Okay, thank you. Entertain a motion for approval of the minutes.
Motion.
Do I have a second? Okay, let's just do a voice. All in favor?
Aye.
Any opposed? Okay, motion passes. So each member of the public that wishes to speak after an item is presented and discussed by the board will have 3 minutes per item. If you're a representative of an association and group, you'll have 5 minutes. Let's do the swearing in, please.
Anyone intending to speak, please stand and raise your right hand. Anybody? Do you swear or affirm any testimony you give at this public hearing will be truthful and accurate? Thanks.
Okay. Our first case, case number 240-40001, 2436 K Lane. Any disclosures first? Milton? Fred?
None.
Doug?
None.
Nope.
Jason?
None.
Okay, and none for myself. Sir, if you could please state your name, relation to the property, and go from there.
Sure. Mario Thatcher, the owner of the aforementioned home. And good evening. Basically, we were here 2 months ago. We had requested variances for 2 items in the home. One was a carport, one was a shed. We have since withdrawn the carport. We're filing, we pulled the permit and we're doing it the correct way. The shed, however, still remains an issue because we do meet the standard of undue hardship. We can't move the shed anywhere. Remember, this is a shed that we purchased the home, and the shed was a part of it. It's been there for 12 years in the same location, same size, same everything. We didn't touch it. We didn't improve it, nothing. Unfortunately, we were sold a bill of goods by the seller who made it look as if it's a living area. So we bought it hook, line, and sinker. And unfortunately, we found out that's not the case, and it's not a living space. So what do we do in hopes of complying? We removed the AC, and it's being used as a storage facility, as a storage unit, basically. We didn't have the proper photographs to show this board 2 months ago. If you recall, my wife was here showing you photographs, but those were the listing photos that duped us into buying it, thinking that it's a living area. It's not. And so we filed current photos showing the exact use of a storage facility. We removed the AC, and it's 88 degrees in that photograph. It is hot. You cannot be in there. And so, short of getting the approval, we would have to remove it because it just wouldn't comply with all the easements that are required, the setbacks and so forth. And so I'm hoping that, and the other thing is, I don't know if you recall, but 2 months ago, again, this board, I think it was one of the board members, exactly, you moved to consolidate and approve all the variances. And I think it was seconded. And then all of a sudden there was some confusion. No, we didn't vote for this. We voted just for consolidation. Had we not consolidated, I believe that perhaps the carport we would have failed on, but the shed would have and should have been approved because we meet the standard of undue hardship not created by our own actions. And so hopefully we can do the right thing today.
Chair, Deputy
Yes.
City Attorney Dwayne Spence, if I can provide the board with some guidance, this is a motion to requesting a rehearing. If the board finds that it meets the criteria for a rehearing, the staff will schedule the actual hearing on the variance request for another time and date. The code provides 2 criteria for consideration. The first being that the rehearing is necessary to correct an error. The second being that that there is new evidence or information that was not considered by the board when it originally reviewed and made a decision on the application. So those are the 2 criteria that you need to consider at this time.
Do we still have the public hearing on this part, or just within the board for a rehearing? Public input or no?
You can have public input, but it's not, yes, you can, yes, you have public input, but it's not on the variance itself. It's on the rehearing.
Okay, thank you. In that case, I'll bring it back to the board for motion or discussion, or any questions of the applicant. Does anybody have any questions for the applicant? No? Okay, thank you, sir. And now we will entertain a motion.
Are we going to discuss or just a motion?
We could discuss.
Okay. I believe that I voted for these variances at the in July. But the question is whether or not we made a mistake hearing them all at once. And it may not have been an error at the time, but in retrospect, because they've withdrawn the one and the other one possibly would have gone through, I don't want to preclude his making a presentation by sticking with the prior denial. And they didn't have evidence of how this shed was being treated. All they had was these really pretty pictures of it looking like a dwelling unit. So I would consider that the new photographs are new evidence. And I would make a motion that we set this for a hearing to rehear the case.
Second.
Okay, before further discussion, do we need to set a specific date?
I think staff does
No,
that.
staff will set the date in accordance with the notice provisions of the ULDR.
Okay, thank you. So we have a first and a second. Any further discussion? No. Okay, in that case, Jamie?
Mr. Hercopin, you seconded it, right?
I did.
Okay, thanks. Mr. Jones?
Yes.
Mr. Mead?
Yes.
Ms. Rathburn?
Yes.
Mr. Stressa?
Yes.
Mr. Hercopin?
Yes.
And Chair Elfman?
Yes.
Pass 6-0.
Thank you. We'll see you at a future meeting. Thank you. Next case, case number 240-20002, 1820 Southwest 22nd Avenue. And let's start with disclosures. Milton? Fred? Okay, Doug? Okay, Jason?
None.
Pat?
None.
And I did have a site visit. Okay. If you could please state your name, relation to the property, we go from here. I'm sorry, one moment. If you could turn the microphone on. Just press the button when it goes red. There you go.
Got it. Sorry. Hi, I'm Annalie Hambrick. I'm the owner at 1820 Southwest 22nd Ave. This is my husband.
Essentially here for just moral support.
Okay.
I'm not great at public speaking. I'm also pregnant and hormonal, so bear with me as my voice cracks. Okay, so can you go to the next slide? Sorry. Thank you. Before you guys voted, I just wanted to kind of give a background on the property history, some special conditions unique to our property, what we perceive as hardships, and then additional considerations. Okay, so some property history. We purchased the home in 2018. As you can see in the top right corner, that's what the backyard looked like when we first bought it. So there was a marina repair facility there at the time with very dense foliage. So our backyard was very private, quiet, and an oasis for us. We bought the house because it had a pool, and we love our outdoor time. In 2020 through 2022, they knocked down that marina repair facility. And as you can see in the middle picture, our backyard was completely exposed to I-95 for those 3 years. So it was a long 3 years. COVID happened. They didn't start construction. And for those long 3 years, all we did was plan how we could fix this because it was miserable. You couldn't even have a conversation in the pool without hearing the noise from the highway overpass. And then in 2023, they started building the marina. I put the picture in the bottom right. This is before we built the tiki hut and deck, just to kind of show that the buffer zone that they added was really just a couple of palm trees. So it didn't do anything to block the highway and the noise coming off of it. You can see the giant boat stacks behind our house, which are obviously a huge eyesore. You can also see the gap in between the two stacks, which is directly in the middle of our specific property. So you can still see the highway through that At that time, I didn't take pictures of that because I was always trying to block that in pictures. So I don't have a good picture of it before, but there will be more coming up where you can kind of see that. You can still see the highway, hear it, and it creates a funneling, like a tunnel effect where all of the noise and soot and like wind comes directly into our backyard and amplifies it. Okay, so some special conditions affecting our property. I put this picture, first, we're located in RS8, which is a residential neighborhood, but I think it's important to point out that while we have two neighbors to the south and north of us, our backyard, which is the entire length of our property, is shared with an industrial neighbor. So it's not a residential neighbor, and they built boat stacks 5 stories high, and we're on top, we're right below the highway overpass. So the backyard's less than 160 yards from the elevated highway overpass. I think it's important to point out that it's elevated and not ground level. So everything, we just see everything from our backyard. It comes right into our backyard, all of the soot and noise, and it's a huge eyesore, and it really inhibits our ability to enjoy our backyard. And this picture to the bottom right is the day that they actually started removing the old boat repair facility, and I thought it was a good example to show that you can kind of see the building to the left that was still there, that was still halfway there, and how that really did block the highway. So when we bought the house, we didn't know that when they took that down, our entire backyard was going to be the highway. We really would have never bought the house if that was the case. You can ask him, as soon as it came down, I wanted to move. And then after, obviously, the removal of the previous building, there was just a huge eyesore of the highway. I'd also like to point out that the tri-rail goes over that overpass, so it's also the tri-rail that we hear all the time, and the trucks and everything else going that way. And then, as you'll see on the next slide, all of the machinery from I have a video here which we'll show at the end, but the heavy equipment that they use to move the boats is constantly going, especially on the weekends, because people want to use their boats on the weekends when we want to use our backyard, and it's constantly just beep, 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 beep as they're moving the boats. Okay, so what we perceive to be the hardships is when we bought the house, there was no exposure to I-95, like I said earlier. The existing foliage that was there has since been removed, and they didn't really provide any blockage or buffer to reduce the noise and everything coming from I-95. Also, now that our backyard is exposed to the highway, we're dealing with the constant noise, the soot from the highway covering our home, which I think is a health impact as well. I know that soot is a carcinogen. We're also expecting a baby in March, and that obviously has implications for us. Also, the lack of privacy from the trains, cars, and other onlookers using the elevated overpass, and then the constant noise of the moving boats. Could you press play on the video? Oh, does it have sound? I won't make you watch the whole thing, but you'll get an idea once you have sound. Oh, thank you. Can you hear my voice?
Don't give birth here.
I'm not quite, it'll be more miscarriage.
Well, sound's not working, essentially, it's just
You're
a
allowed
5-minute video.
Yeah, exactly.
Yeah. I'm sure
And
you've all
it's
heard it before,
non-stop on the weekend. Like, people want to use their boats on the weekend. It is non-stop. Okay. Sorry. It's okay, yeah.
We've all heard beeps before. I can deduce from there.
Thank you. Sorry. Okay. Some additional considerations that we just wanted to point out to the board is that, again, it's an industrial neighbor, and then with the entire length of our backyard that we're fully exposed to. And they do have boat stacks that are 5 stories high. So one of the variances is the height of both the deck and the tiki hut. And I know that, like, we should have gotten permits and everything before the tribe. They told us we didn't need permits. We blindly believed them. It was our first house project. Again, we saved up forever to do this, and we just, like, wanted to make our backyard something we could enjoy again. So we just weren't thinking about those things. But we do think it's fair to point out that, you know, the eyesore really is the boat stacks that is behind our house. And our tiki hut, in comparison, as you can see in the bottom picture, is much, much smaller than that. Also, our property in particular, which you can see in the bottom picture and the top picture, is right in the middle of the split of the two boat stacks. So again, it creates that funneling effect where we really get the amplified wind, sound, and soot right into our backyard. And the tiki hut has effectively blocked that, at least the highway view, and all of the soot coming off of it. The top of our deck gets covered in soot, but at least doesn't fall into our backyard and our pool. Thank you. Also, one of the variances is the 5-foot setback for both the deck and the tiki hut. We put a picture or a screenshot of the agreement we had with the marina, where they said that we can construct a wall or fence running east-west along both the north and south property lines of the single-family property to the buffer wall, to a location that abuts and touches the wall. So when we saw that, we thought that was our property. Like, we could build up to there. We've now come to find out that it really goes to about where the rocks start, but for all intents and purposes, the marina's not going to use that location, and the exterior posts are all 5 feet from the wall. We've also since learned that it counts from the overhang. We can cut back the overhang, but obviously aesthetically we'd prefer not to. So obviously we're just coming to hope to not have to do that. And yeah, that's it. Okay. Yeah. Okay. And then for the elevated deck, again, the tribe told us we could do this. We believed them. We didn't know that it could only be 2.5 feet tall. But the reason we built it was twofold. So we had the tiki hut to block the highway, but we also had that to extend some of the blockage since, the whole backyard is exposed. And we also built it because we can see the waterway. You can see in the top left corner, the yachts are blocking it, but before that you can see the waterway and everything moving back and forth. When the yachts aren't there, we love to sit up there and kind of just watch the boats go back and forth, so that's why we built it elevated. And then also from the top of our deck, you're unable to see either of the residential neighbors' yards from both the north and south. So the middle one is the neighbor to the north. She is running late, but she is here. She will be here in support if you want to wait to vote to hear from her. And then the neighbor to the south, that's the picture to the right. The view is completely blocked by all of the foliage, and they are here in support as well. They're here, and she also wrote a letter, but she just handed it to me, so I don't know if you guys want that.
As well as the neighbors that are across the street.
Yeah.
As well, sitting here in support.
Yes, we have a slew of neighbors here that are all here in support. And yeah, the other considerations that I didn't put here because I don't know if they're legitimate, but I just wanted to point out is that, again, the tribe lied to us. We spent our entire savings on this. I was really ready to move out, so we put all of our savings into building the tiki hut, which instead of a down payment on a new house, so now this is kind of our last resort and last hope to be able to enjoy our backyard. So I hope you take that all into consideration.
Thank you very much. If you would, just I'll let you sit down right there. I think there's, is there anybody from the public wishing to speak? Or just emotional support? Up to you guys. If you want to, if you'd like, yes. And have you been sworn in, sir? Have you been sworn in?
Yes.
Okay. Then please just go up there to the microphone, state your name, property address, and go from there.
My name is Mike Resta. Live at 2040 Southwest 22nd Avenue. Recently sold 2030 Southwest 22nd Avenue, and at one point we owned 2 other properties on this same block. I originally moved to Flamingo Park in 1976 and have been there ever since. I've been in this room several times for different permits and this, that, and the other. I recognize some of you. I was in the room back there with Nick Kalageros and Ella Parker with the development of the boatyard, and there were a lot of contentious issues, like the height. This boatyard ramp right behind Anna Lee's house has got to be 90, 100 feet tall. Beep, 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 always with the boats in and out. But I go back to the time when the boatyards, Amity, National, Roddy, Chris Craft, they had some good old boy thing going on in that neighborhood where they were actually using homeowners' property to access what they called their island property at the end of the block. So every house on that block, including two of mine, were giving up space for 40-something years, 50-something years, to the boatyard. And the boatyards always swore that's their property, their property. They were on our property that we paid taxes on.
Yeah, and sir, I'm going to kind of reel you in because I believe you are in support, so I'd like you to share as far as your support.
Understood. Just a little background. Way back when, all of these properties abutting the boatyard were what they called transitional zoning between commercial and residential. And I was told when I went downtown and looked in this giant Bible to read through, you were able to have a small business in your backyard because you abutted commercial property. They did away with that for a lot of different reasons, fine and dandy, but the complexion of the neighborhood has changed. When these youngsters move into the neighborhood, I welcome them with some small pastry, welcome to the neighborhood. I've seen things change, and it's great to have new blood in the neighborhood, vitality for the neighborhood. Now, I've seen this tiki hut. You can barely see the top of it over their house, and I have full understanding why they would want to put this thing, because right in their backyard, there's a 100-foot-high monstrosity that they're looking at.
And sir, if I could ask you, because we're past our 3 minutes, if I could ask you to wrap up.
Yeah. I'm here in full support for whatever they're doing. A foot too high with a railing, 10 square feet too big with a deck. What is it all about? It comes to a nothing burger, and I think a waste of you ladies and gentlemen's time, because this has been nothing but positive for the neighborhood. And I can't imagine what would be wrong with allowing them to keep it the way it is.
Thank you, sir. Is there anybody else that would like to speak from the public? Oh, that's okay. I'll bring you back if I need to.
Okay, she wrote a letter.
Oh, if she wrote the letter, if you wanted to read it? Sure. You could come up and read it.
I don't think she wants to. Can I read it?
You could read on her behalf and announce her name, and you confirm that's you. We can read it.
What's the property, 1810 or 1830? 1830 Southwest 22nd Ave. Bear with me. It's the city of Fort Lauderdale. Because of the adjustment meeting, I reside next door to the right to my neighbor Annalie Andrews, now Hambrick. I wish to approve of the tiki hut with the raised deck. I think that it is beautiful, tropical, and I can hardly see it from my yard. I have to walk out front to the sidewalk and look down between our houses to see a little piece of the deck. They are good neighbors. They are quiet. Please approve the changes. I have no problem with the property. It's a 10,000% improvement over the gigantic disaster backed up to us, the boat deck, and signed Norma C. Bryan.
Okay. Thank you.
Thank you.
Yeah. If they could keep it for the record. Thank you. Anybody else? Okay. You have been sworn in or you have not? Okay, we will swear you in now.
Do you swear or affirm any testimony you give at this public hearing will be truthful and accurate?
Okay.
Hi, I'm Petra Canaris. I'm one of the owners with my fiance at 1801 Southwest 22nd Avenue. We're right across Annalie and Ian, so I just want to really make it short and sweet. This is something that they enjoy. We all really get to enjoy as a community. Really, they're very great neighbors. It's never been a nuisance to us. We don't see it anywhere near us. They cannot see us through our backyard, and so I don't see the issue of keeping it, and that's all I want to say. Just in support of them.
Thank you. Okay. I don't see like we have much opposition out there. Okay. Well, we're going to bring it back to the board and see if there's any discussion, if we have any questions of the applicant. So we'll have you come back up. Okay. I'll close yes, thank you. I will close the public hearing at this point. I will also state, by the way, that I have visited by your property, and I did see quite a huge boatyard behind you. So
Yeah.
I don't know if your pictures really showed it to the extent,
Yeah.
but I was able to see that.
Okay. Thank you.
Doug, you have a question?
I have a question of the staff. It would seem to me, and if not, it's sad that there is not some requirement in this whole development that they did not have to put up a buffer zone of trees and whatnot behind these houses, that they were allowed to do what they're doing, and they can sit with street lights that are beaming into the residential houses. So is there code? Should these people have been held accountable to make this livable for the neighbors, or where they can just tear down what was there and have no buffer zone at all? And also, I believe, I'm not sure, the code compliance, there is a noise. So if those beepers are more than the noise, you should talk to code compliance about that as well. But is there something that these people should be forced to do for all the whole neighbors?
Well, the Marina project did go through the DRC site plan approval process, and part of that is neighborhood compatibility requirements. They had to put up the wall that she showed in her photograph. That was the requirement that they had to do to meet neighborhood compatibility, provide a sound buffer and a visual barrier between the two. Granted, it probably needed to be 50 feet tall, but that's not what the code requires.
So that's...
Thank you. I mean, yeah, it's
On
hard.
behalf of the city, I apologize from everybody who works here.
Thank you.
And I don't, but it's
glad you
sad
understand.
that is able to be done in your backyard.
Thank you very much. Yeah.
Okay, Fred, do you have a question of the applicant?
Yeah, I had the same question, and I spent a lot of time. I actually went over there twice. And I guess I have a question because every project that I was ever involved in a design where we had a commercial development that backed up the residential, we had to provide a landscape buffer. And I had a note that from the street you can see the lights in the marina complex. I didn't go over there at night, but it has to be absolutely the worst thing that these people have had to ever deal with. And I would like, and it's not going to affect our vote tonight, I don't think, I would like to have a report from the staff as to why there isn't a landscape buffer between the commercial development in their house, and I would like to have some idea of whether or not they provided the photometrics of the lights that they've installed as to whether they meet the code requirement. And lastly, if these people need help in having the city code enforcement come and check the beeping on the sound, I'd like to find out how we can advise them to do that. I just find it's appalling that this got built without any kind of buffer or landscaping between it and the residential housing.
Thank you.
Okay, Pat?
I just had a question for staff. If we approve these, they have to get the deck permitted, right? But the Tiki Hut is fine because the Seminoles don't need one.
Was it built by Seminole?
Yes, it was.
So they still need to submit a zoning permit. If the documentation is submitted for the tribesmen and everything's fine, then they don't need a structural permit. As long as there isn't anything been built into it, it can only be just a tiki hut. There can be no.
No, I'm talking about the deck. Do they need to get a permit for the deck?
No, they need a permit for the deck and for the tiki hut.
But if the Seminoles built the
They still
tiki hut,
they still need a permit for location for zoning.
okay.
So they still have to physically submit a zoning permit.
Which we have submitted applications. for
And
both.
I just want to take 1 second and tell you that we have a lot of really good attorneys that appear before us that get paid a lot of money to put together these packages, and your package is equal to theirs. So kudos to you for really
You're gonna make
addressing
me cry again. I'm horrible.
for addressing each and one of all of the hardship and all of the criteria. So you did a really good job.
Thank you so much. I appreciate it. I care a lot about this, so.
Okay.
Yeah, thank you for making it very clear and easy to understand the
Thank you guys for
situation at
understanding.
hand. We don't always get such complete packages. I am a licensed architect, so I practice quite a bit all over the place. And just to our viewers out there and to those in the audience, when anybody tells you that you don't need a permit for something, please do not
Never again.
believe them completely.
There are permits, not complete permits, like our planning director has just stated. You don't need a structural permit for the cheeky huts, but you do need to get approvals from planning and zoning. These things do fall inside setbacks. They do have to be approved. So it's not a lesson to you in particular, but just in general, just buyer beware, please. I mean, obviously, you're in a very complicated situation. We have two different types of zoning that are abutting each other. It's kind of like the worst case scenario, right? This is why we don't like to see spot zoning, because it's just not, it creates awkward situations such as this. So, I mean, you probably knew this when you bought the house, like, oh, it looks like there's a commercial property behind us. Something might happen here.
Yep, but it was fully blocked and we had our own
Right.
oasis. We just didn't
So
know.
something did happen, I guess. I can see from their plan that their racks are set back. There is like this area, so I'm sure there were some processes that happened when this was built. Perhaps there was a landscape, something was supposed to happen that maybe is not there.
Yeah.
But, you know, we're here right now, and we're in this very awkward situation, and I would say, you know, and at first I was wondering why you built this deck up high, because I'm like, what do you want to be like? But I see you have the water view, so you wanted to get in there.
Right.
I would be very kind of against such a thing if you were abutting, for instance, another residential set of homes behind you.
Yeah, of course.
You know, the reason why you're here, you know, and I don't know what triggered it, somebody, if a neighbor or somebody.
We don't know either. We really have no idea.
Interesting. Okay.
Yeah.
So
It happens.
Was there a specific question you could ask?
No,
And otherwise,
no,
we'll bring it back.
Yeah, okay.
Okay. Any more questions for the applicant before we bring it back? Okay. Thank you so much.
Thank you.
We're going to bring it back to the board for a vote, motion.
I make a
Any other
motion
discussion?
to approve,
Let's do them individually, Pat.
okay, 4719-1J, general requirements. Making a motion to approve because they've met all of the criteria for the granting of a variance.
Second.
Okay, motion and a second. Jamie? Oh, any further discussion first? Okay, Jamie?
Mr. Mead?
Yes.
Ms. Rathburn?
Yes.
Mr. Stressa?
Yes.
Mr. Hagopian?
Yes.
Mr. Jones?
Yes.
And Chair Hoffman?
Yes, motion passes.
Okay.
Pat, do you want to go 2 for 2?
Sure. Make a motion to approve 4719.2G2 accessory building structures and equipment, as the applicant has met the criteria fully set forth in the code.
Second.
Member, please note there are 2 variance requests under that section.
I don't need to list both of them. But
Just for the record, I want
to grant
clarify that.
both of them under
Thank
that
you.
section, yes.
Okay.
Okay, thank you.
Second.
Okay, motion and a second. Any further discussion? Okay, Jamie?
Ms. Rathburn?
Yes.
Mr. Stressa?
Yes.
Mr. Hagopian?
Yes.
Mr. Jones?
Yes.
Mr. Mead?
Yes.
And Chair Hoffman?
Yes, motion passes. Did we have 3 or did we combine the last 2? Combine the last
No,
There's
no,
one
it
more.
wasn't.
There's one more.
One more?
So there are 3 code sections, and then there are various variance requests. So under the last code section that they're requesting a variance, there are 3 variances underneath that code section.
All right. I make a motion to approve the 3 requested variances under section 4719.2P freestanding shade structures because the applicant has met the criteria set forth in the code.
That's it.
Okay, motion in 2 seconds. Any discussion? Jamie?
Mr. Hagopian?
Yes.
Mr. Jones?
Yes.
Mr. Mead?
Yes.
Ms. Rathburn?
Yes.
Mr. Stressa?
Yes.
And Chair Hoffman?
Yes. Motion passes.
6-0.
Okay, thank you. On to your next steps. Okay, next case, case number 240-80003, 2330 South Federal Highway. Do we have an applicant? Okay. And sir, have you been sworn in?
I have, yes.
Okay, wonderful. State your name, relation to the property.
My name is Damian Leslie. I am with MDM Services. We are the consultant for the owner, who is with this petition anyway. The property, as you said, is located at 2330 South Federal Highway. It is bound by US 1, 84, and Miami Avenue. We are requesting a variance to allow this site for redevelopment. It is currently a gas station and has been so for a number of years. The code specifically requires that there is a distance between this particular use, which is in the B1 district, and a park. And so we, by the pre-existing conditions, are...
You're here.
Yes. And so we would like this variance heard by the board, and we'd appreciate support in this. It's a wonderful park, and the code requires, I think, 300 feet, and we are just under 100 feet separated by the right-of-way of 84.
I'm sorry, 1 second, sir. Excuse me in the back. Could you take that outside, please? Thank you. I apologize.
Sure. Do I need to repeat anything, or?
I think we got you up to that point.
Okay. And so, yes, we'd just like the board to consider the variance request for our site. It's going to be a redevelopment. I didn't know if I mentioned that, of the gas station. We hope to revitalize that area. The use is going to be the same, and we just hope we'll be able to do that.
Thank you. I'm going to go backtracking in here, and I'm going to ask for disclosures. I apologize, didn't before. Milton?
I don't have any.
Fred?
Site visit just about every day.
Doug?
No.
Okay.
No.
Jason?
No.
Pat? And nothing for me. Thank you. We'll continue on. Okay. Let's hang in there 1 second. Is there anybody from the public wishing to speak on this matter?
Good.
Okay. Seeing none, I'm going to bring it back to the board for any questions of the applicant. Milton?
I don't have any.
Oh, okay. Your light was on. Sorry. Fred?
Okay. I don't have any questions. I just want to tell you that having lived with that service station the way it is presently designed is a nightmare. And although I think the new site plan has some problems with circulation, I think it's an immense improvement. And for those people that didn't go by the site, I think you have to realize that there is almost no way that anybody that would like to use the park on the south side of Route 84 can even remotely walk or drive over to where this property is because of the concrete median that runs down the middle.
Thank you, Fred. Anybody else have any comments, questions for the applicants? Okay. In that case, sir, thank you. You can have a seat. We'll bring it back to the board for a vote.
Thank you.
Okay. Any board discussion, or if somebody would like to make a motion? Oh, Jason's
Sure,
ready.
I'll
Use
make a
microphone.
motion to grant the variance, section 47-18.5.c, due to the fact that the client has met the existing hardship and this is currently in the same use as it proposed as what is there now.
Second.
Okay, motion and a second. Any discussion? Okay, Jamie.
Mr. Hagopian?
Yes.
Mr. Jones?
Yes.
Mr. Mead?
Yes.
Ms. Rathburn?
Yes.
Mr. Strissel?
Yes.
And Chair Elfman?
Yes. Motion passes. Thank you. Okay, next case, final case, case number 240-80004, 1612 Southwest 12th Court. Do we have an applicant? Okay, I'm going to ask for disclosures while you're walking up there. Milton?
Don't have any.
Okay. Fred?
I got to make sure I got the right one. Yes, I have been to the site.
Okay. Doug?
No.
I had a site visit. And
Nothing
Jason?
for me?
Pat? Okay. Sir, please state your name, relation to the property.
Good evening. My name is Ryan Tucker. I am the owner of 1612 Southwest 12th Court, along with my wife, Christina. My wife is not able to be here tonight as we had our second child 2 weeks ago. She's recovering from a C-section and is taking care of him as we speak. So this is a request for a variance for a existing carport that we have come to find out was built within the setback that we did an enclosure for. The carport originally was permitted back in 1962. It has been re-roofed a couple of times throughout the years, and when we purchased this home in 2019, it was no longer acting as a true carport where you would park your car. It did have an existing wood enclosure surrounding the carport, so we were not able to use the space for our cars. Instead, we used it for some storage, mainly outdoor lawn equipment, bicycles, that kind of thing. Over time, the wood outside had begun to break and become a bit of an eyesore. And as I just stated, we've kind of begun to grow our family, and so we needed some better storage space that was not impacted by the elements and would not become really dirty. So we decided to enclose it. I will disclose that we did not permit this originally, and I do regret not doing that at this point. Again, kind of similar to Anna Lee, first-time homeowner, not kind of aware of everything to do here. But the space has existed there. We enclosed it with cinder block. I do have the drawings that I submitted within that package of how it was done, and we will absolutely plan to get a permit following this variance request.
Okay. Thank you. I'll have you just stand by. There may be some questions. I would ask, and I'll ask real quick, anybody from the public wishing to speak on this matter, seeing that there's nobody left out there in the public to speak, let's bring it back to the board. Is there any questions for the applicant? Okay. In that case, sir, I'll let you sit back down, and we're going to bring it back to the board for discussion. I will say I have been to the property. Not saying that this is any good excuse, but you did do a very nice job, and I was really looking to see if it was interfering with any sight line as I was going around the corner. And the good news is it was back far enough that I didn't feel it was. That was just my comments of a site visit, and I'll leave it to my fellow board members for any comments.
I wish you weren't so much. I mean, it's a 25-foot front setback, and you're 13 feet closer than you're supposed to be. It's a big ask for me.
Okay. Anything else for the board to discuss, Fred?
Well, I guess I got into it because I was curious. It was permitted by the city and signed off apparently in 1962. And the question that I had, Bert, is whether or not I asked Bert to research what the definition of a carport was in 1962 or 68, and there aren't any records that he could find, and I don't think it is particularly relevant. I was just kind of curious. And then apparently somewhere along the way it was enclosed, and I asked whether or not there was a permit to enclose what should have been an open carport. And I don't think that there was a permit that the people pulled to actually enclose a permit. And again, I'm not sure it makes any difference other than I was looking for the historical background of what is there. Today, a carport can only be enclosed on 3 sides. And so obviously this doesn't fall into that, but in answer to the previous member's question, it was permitted in exactly where it is. And in looking at what they have done, it more than fits into the neighborhood from an aesthetic standpoint, and I don't think that it has anything to do with any sight lines. I went around. That was a new neighborhood. I've never been over there and got sidetracked in all the one-way streets. It's kind of an interesting, lucky layout, actually. But I think that probably it's an addition to the neighborhood, and it doesn't really affect anybody in the neighborhood.
Okay. Yes, Doug, of course.
This is a unair-conditioned storage space. It's not an addition to the house.
Correct. It's not.
So it's not a baby's room.
No. Golf clubs.
Yeah.
You know, that kind of thing.
Yeah.
Yeah. I mean, that's the problem, is it starts as a carport, then you put up cheap walls, then you put up good walls, and all of a sudden it's an extension to the house where it was supposed to be a carport that technically probably was, you view through it originally, to protect your car from the sun, and now it's a completely different animal, but you're going back to, they permitted it, but they permitted it for something completely different a long time ago.
Okay. So, and I'm sorry, if you're going to speak back, I'm going to have you come to the microphone.
I apologize. I realized that I failed to submit a picture of the interior. I did have my wife just send me a picture tonight. I don't know if that's possible to show you all, but it's again, it's got our golf clubs, it's got, extra paper towels, that kind of thing.
Yeah, we're going to take your word on that right now because any picture you're sent, we can't put in public record.
Sure. Okay.
We could and not give it back.
Am I able to send it as an email to anyone, or?
I think we're okay.
Okay.
Thank you, though.
Okay. Thank you.
Okay. If there's no other questions, let's bring it back for a vote. Anyone? Come on, Pat.
All right. I think we're on a roll here. I agree with Fred that where the location of this was permitted in 1962, the only thing that they're doing different is enclosing it, and the setback is the same as it was. They bought it like that. They obviously bought it assuming that they could, it was enclosed when you bought it, and they obviously thought that it was legal. Next time, get a lawyer. But I make a motion to approve the variance as they've met the criteria.
So we have a second. Okay, motion and second. Any further discussion? Okay, let's roll call.
Mr. Jones?
Yes.
Mr. Mead?
Yes.
Ms. Rathburn?
Yes.
Mr. Stressa?
Yes.
Mr. Hagopian?
No.
And Chair Elfman?
I'm just going to make commentary before my vote. My commentary is that I was very concerned whether this being a corner property, if you were able to see around the corner. And the fact is it was set back enough where I was able to clearly see. So my vote, yes.
Yes, okay. So pass 5-1.
Okay, thank you. Motion passing. Next steps, permits. Okay, being no other cases, do we have any communication to the City Commission?
Yep.
Okay, Fred?
Many, many meetings ago, I asked whether or not it was possible from the appropriate person in the city to advise the Seminole Indians as to the problems that we are encountering as a result of them building without a building permit. And as near as I can tell, it didn't happen. We continue to have to hear about tiki huts that are constructed without the proper zoning. And I would like to have Dwayne advise the board as to how it is appropriate to mandate that the city commission have somebody with authority advise the Indians of the problems that they're creating because of their zoning issues with what they're building. It's absolutely, these cheeky huts cost $15,000 to $35,000, not even looking at what these people had tonight, which was probably somewhere in the neighborhood of $80,000 if it was a dime. And we could have turned them down and have turned others down and will turn others down. But it is criminal for the city not to advise the Seminoles of the problems that they are creating for the citizens of the city of Fort Lauderdale.
Okay, on our own initiative, we can send something to you, to the Seminole tribe and the Miccosukee tribes, which are the two tribes that are able to build these structures without a building permit, assuming that they do not incorporate electrical, plumbing, or other non-wood features. So we can highlight the statute. Well, I think a telephone call to them first would probably be good, and we can report back to you on our own initiative, rather than putting the board through the hassle of having to communicate that to the commission. And hopefully we can get a satisfactory answer back to you.
Well, I trust you and Tom, but the last time I brought this up, which was months ago when we were discussing the one that's clear up in the northeast section, that I don't think anything ever happened. And it's frustrating.
Well, Fred, I agree with you, but and I think that's a great solution for Dwayne, but the problem is it's not like the political organization of the Seminole Tribe has a list of every member that's out there building these things. So, we can send them a letter and they can say, okay, we understand that. They're not going to send out, a newsletter to everyone in the tribe telling them not to do this anymore. So I see no harm in doing it. I just don't see that it's going to have a lot of
We'll
effect.
reach out and we'll report back.
Yeah, I just don't want to have to sit here night after night and look people in the eye and say, sorry, we can't do anything about it.
And I would be, and I'm interested in the nuance and whether or not they understand the statute themselves, because it might be a case where, as most common folks believe that once you're building a cheeky hut, and their definition may be broad, that of course you don't need any permit, is probably what's been communicated out there, and they don't understand the nuance. And so we can check in and see where that can be clarified. Again, not to have your expectations inflated, because of course, there are different providers that are probably building these structures, but we'll reach out to their tribal entity and see what kind of response we get.
Well, I think that letter needs to include what they can do as far as the height and what the requirements are.
I mean, we want to tread lightly because they are a sovereign entity. I mean,
Okay, I just don't want to have to face another homeowner that's going to cost them $35,000 when we say no.
understand.
Okay.
Understood. Yes.
So we'll let you do your first step as you committed and look forward to your report back. Is there anything else for the good of the city? Okay. Seeing none, we're adjourned. Thank you. Oh, what? Oh. Okay. So, what are we rescheduling? We did this
If you recall the State of the City address.
So the meeting will be changed from October 9th to October 8th, which is a Tuesday.
I make a motion that we move the October meeting to October 8th from October 9th.
Second? Okay. Any discussion? Voice vote. All in favor, aye?
Aye.
Any opposed? Okay. Thank you. We got that done. We will reconvene on October 8th. Meeting adjourned again.